All right, we are going to do a session today that's going to focus on MBE. You may have noticed from the schedule for these classes that most of the sessions have a Florida cast to them, primarily because the commercial courses focus very heavily on the MBE portion, and I've found in the past that most students want a little bit of extra help on Florida. But with that said, I do want to take time today to talk about the 7 subjects now that are going to be tested on the MBE portion. And the question pack that you have, some of you received a pack that has just 12 questions. Susie went upstairs. There are 14 questions now because the new pack includes some civil procedure questions. So she's going to bring those back down. They'll also be on the screen. I apologize. There was a little mix-up in what we brought downstairs. But what we're going to do today is talk about MBE questions, and in particular, how you approach the subjects. There's a thought process to each subject. And the more that you key into how that works, the better job you're going to do in answering the 200 MBE multiple choice questions that you have. Now, let me ask, as I jump in, how many of you, and I see some of you who did take ALS, how many of you did not take ALS? Okay, about half and half. All right. What I want to do then, for those of you who did take ALS, some of what I'm going to be talking about here should sound familiar, but you know what? Doesn't hurt to hear it again. And of course, for those of you who did not take ALS, some of this is going to be new territory for you. Let's talk about the format of MBE style questions, because for the MBE, you're going to get a very clear format style. You'll have an occasional question that steps outside the format, but almost all of the questions will be in the same format. You're going to start first with a short fact pattern, 500 words or less, and the fact patterns tend to be shorter now. You may find as you go through your MBE materials in your various commercial courses, you may find longer fact patterns. And sometimes it almost has to be longer. Property questions, for example, tend to be a little bit longer. Contracts questions tend to be a little bit longer. On the other hand, evidence questions are usually very short. So you're going to start with a fact pattern. For the new style MBE questions, which means what you will see on the exam, every fact counts. There are no red herrings in the MBE style questions. So your job as you read the question is to look at every word and say, what's it doing here? What's this fact here for? And you already know, I think, from your various classes in law school, the key to doing well on the multiple choice questions is to interact with them. Mark them up. The more you mark up your booklet, the better job you're going to do reading, and the better job you do reading, the better job you're going to do on the question. The bar exam is going to test a lot of knowledge, which you've already figured out, but it's also a reading comprehension exam. If you know tons and tons of stuff, but you don't read the question carefully, you're still going to get it wrong. And while you're going to miss a question here and there because you don't know the law, it's going to happen. Nobody knows everything. Not even me. Not even me. You know, and I go through this exam twice a year, and I've been doing bar prep for a really long time, a lot longer than I'd like to admit. Every year I learn something new, and I go, wow, how come I didn't know X, whatever X is? And that's the beauty of the law. There's always something else to learn about the law. You just have to know enough. But what I do want to say to you is if you miss a question because you don't know that particular exception to the rule, it's going to happen. If you miss a question because you didn't read it carefully, then shame on you, right? Don't give away questions because you're not reading carefully. Mark up that packet. Now, once again, you've got a short fact pattern, and it's going to be followed by the call of the question. which is going to be short and to the point. It's not going to be, just a very broad who wins. It's going to say, in this case, if the girl sues the boy for battery, will she win? And you've got to make sure that you are answering the call of the question. Of course, we're going to talk about that next week when we begin essay writing. And in case there's anybody who's here today hoping to get my predictions, that's next week. Oh, yeah. Next week, okay? So you got to come back one more time. But I will give you my predictions next week. But for MBE purposes, that call of the question is absolutely essential. Now, what do you do first? Do you read the fact pattern first? Do you read the call of the question first? It's an individual thing. A lot of people will tell you read the call of the question first, and you can get some advantage out of reading the call of the question first. I don't. So I'm going to tell you what's good and bad about both approaches. Try them both. Do yourselves a huge favor, and don't do it just because somebody else tells you to do it. Do it because it works for you. So for those of you who start with the call of the question first, well, here you know at least it's about battery, right? So it helps you read the fact pattern. It's good for that. What's problematic about reading the call of the question first? It takes more time. If you read the call of the question first, and then you have to read the fact pattern, and then you come back and you read the call of the question again, it takes more time. So if you are a slow reader, and you have to know, some things about yourself. If you're a slow reader, then you might have to think twice about reading the call of the question first. Why do I read the fact pattern first? Because it makes me engaged. Now, I'm a fast reader. I read too fast. And if you read too fast, you miss words. That's what reading fast is all about. You just kind of look at the page and suck it in and hope you got enough out of it, right? And some of you, that's how you read, right? Really bad for the bar exam. Really bad for the bar exam. You miss one little word, a least likely, or a not, or something like that, and you blow the question that you should have gotten right. So I read the fact pattern first because it makes me read every word. And if you watch me, if I do questions with you, I'm going to get out a pencil or something. And like a little kid, I point to every word. Why do I do that? Slows me down, makes me read every word. And I circle and I underline and I draw pictures. But I read the fact pattern first also because I try to predict the call of the question. And if I've done a good job of reading the fact pattern, I predict the call of the question. I know I'm going to get the question right. So you have to do a little more engagement. If you read the call of the question first, you don't have the benefit of seeing the call of the question. But it slows you down if you, like me, are a fast reader. And it also gets you more engaged in the fact pattern. And you don't screen things out. Again, though, try both techniques. Thank you. And this is a brand new laptop that was plugged in 15 minutes ago. All right. Does anybody know where they moved the plugs to? I mean, there's one there. Well, okay. Hopefully this reaches. Yeah, you would think they would be over there, Amara, but they're not. Okay. Okay, folks. If I trip and fall, tort, right? Okay, and it's not assumption of the risk, right? We'll get there. Okay, so once we get past the call of the question, we've got 4 answer choices. And here's a place where you can help yourself out a lot. And you'd be surprised, and could even be some people here have done it. 4 choices, right? Don't pick E or F or G or whatever, and you're all laughing, but somebody will. You get a 25% chance of getting the right answer if you pick A, B, C, or D. You get a 0% chance of getting the right answer if you pick E, F, or G. So just little things can count. So 4 choices. And the typical MBE style question has 2 pairs. 2 yes because and 2 no because. There will be an occasional question that's outside that mold, but it is an occasional question. So if you are used to other styles of questions from your law school exams, be aware, this is what you will see on the MBE portion. Your job, of course, is to pick the right answer. The right answer is going to have the right result, yes or no, matched with the right reason for the answer, which is what follows the because. And so you've got to match up again the result with the rationale, and that's what's key. Now let's take a quick look at this question. And as we go along, I'm going to point out some things that you should keep in mind as you read questions. It's a torts question. I took the question from a note case in Prosser. Why'd I do that? On the bar exam, every subject, you'll see it more, it'll be more obvious when it comes to constitutional law and criminal procedure. But in every subject, they base the questions on real cases. Why do they do that? Because then you know what the answer is. It's the holding in the case. So be aware of that. If you recognize a case, that's good. Look for the result, look for the holding in the case, and that's your right answer. So in this particular fact pattern, what do we have going on? We've got a 5-year-old girl, and she's playing in her yard. 5-year-old girl, what does it make you think about right away? She's a kid, right? And right away you think of what case? The chair case. And Yosue's right. You don't have to know the name of the case. But you want to know it's the case involving the kid who's 5 3/4 years old, and he pulls the chair out from underneath the elderly woman, right? Think about cases. It helps. So she's 5 years old. She runs onto the lawn of the house next door. And then there's a kid, 7 years old. I'm telling you, I'm telegraphing, you know, you got to start thinking about kids, right? And that case, of course, Garrett versus Daly, involved what tort? Anybody remember? Battery. And this particular case that I took this from also involved a battery. See how you want to make those connections. Don't just stare at the page, make the connections. So there's a 7-year-old boy. He sees the girl dart onto the lawn. Now, he grabs his bow and arrow. And he says, if you don't get off the lawn in front of my house, I will shoot you with this bow and arrow. Which might sound like what? Assault, maybe. Question is it immediate enough? But let's keep reading. He intends merely to frighten the girl, shoots the bow and arrow, but what happens? Hits her in the eye, causing her serious injury. What do you think about when you see that particular sentence? Transferred intent. Now, depending on who you had for torts, you may have had a professor who taught the old common law definitions of intent for assault and battery, which are separate. Second restatement. Anybody have a professor who taught second restatement? So you know, if you remember that far back, right? Second restatement combines the two, and you don't need transferred intent. But look at the detail you have to be thinking about as you read the question. Now, I know you haven't reviewed torts yet, but see the steps you have to go through. So now we get down to the call of the question, and it is, of course, a torts question. If the girl sues the boy for battery, will she win? Now, you must circle, underline, put stars by, everything you can do to highlight battery. Why? Because a favorite trick in a tort question is to give you one tort in the call of the question and a different tort in the answer choice. And that different tort in the answer choice looks really juicy, and some of you already said negligence. Yeah, maybe there is negligence here, but it's not going to be the right answer, right? Because the call of the question is battery. So let's look at our choices. A says yes, because the boy intended to frighten the girl. What do you think? Does that look good? I'm seeing a lot of, what don't you like about A?
It's not a complete rule.
It's not a complete rule, okay, so maybe you write a little note there, but what does it tell you about intent? Is it the right intent? No. It is yes it is. Transferred intent. He intended to frighten her, transferred intent, right? Assault, battery, trespass to land, trespass to chattels, false imprisonment. Your 5 transferred intent torts. Look at all the stuff you've got to keep in mind. It looks like an easy question, and it is, but not if you don't go through all the steps. B, yes, because the boy was negligent when he aimed the bow and arrow. Anybody want to pick that choice? Why not? It's negligence. The call of the question is battery, an intentional tort. C, no, because he intended only to frighten her. Now, some of you would have picked that choice, right? Because you forgot about transferred intent. And D, no, because the boy was only 7 years old. Garrett versus Daly, how old was the kid? 5 3/4 years old, as a little kid will be very proud to say. Is D the right answer? Nah, it's not the right answer. No. An intentional tort, we don't have an age limit on intentional torts. That's Garrett versus Daly. What did the court say in that case? Yes, because he intended to frighten her. Transferred intent. Now, it's not a complete answer, and guess what? You're not going to have a lot of complete, beautiful statements of law as answer choices unless they're wrong. Oh, and you're going to see that as we go through these questions today. You may see a beautiful, perfect statement of law, but it's the wrong one. That's what we call a distractor. It's there to try to get you to bite. So if we look at what's going on here, A is the right answer. And also beware, the perfect answer that you're looking for is oftentimes not there. And you've got to pick the best out of the 4 that are offered to you. So, and don't do what everybody, including myself, does when you can't find the answer you want. You get frustrated and you pick a stupid answer. Everybody does it. Resist that impulse. Slow it down. If the one you want isn't there, slow it down and pick the right one. Now, I just said a word that a lot of you don't want to hear. Slow it down, right? Speed kills when it comes to multiple choice questions, folks. And I know it's been drilled into you, 1.8 minutes per question, hit it, move on. Don't get so wrapped up in the time that you don't let yourself read. This particular question is probably average in length. Contracts question, a property question might be a little bit longer. Those evidence questions are short. So maybe it takes you 2 minutes and 5 seconds to read carefully a property question and get it right. You get an evidence question next, 15 seconds and you're done. Don't rush through the questions because you would be amazed at how quickly your accuracy rate falls if you read too fast. Why? Because you start missing words and you don't give yourself time to say, oops, transferred intent. It's an easy question if you keep transferred intent in mind. All right, I thought Susie was going to come back with those questions, but I guess, oh, we do have some. Okay, go ahead though, the first questions are in order. And so I'm going to ask you to do question number 1. You're going to click in and Amar will pass out And for those of you, if we don't have enough copies, all of the questions except for the 2 CivPro questions are identical. So let me get this started, and you can do question number 1. Just question number 1, okay? Yeah, just number 1. Okay, folks, we're coming up. Thank you very much. We're coming up on 2 minutes, and we're missing a lot of people. Do you all have, and, you know, give it a go. I know you haven't done all of these subjects, but one of the reasons why you want to try these questions today, you got to get started someplace, and you've got to sort of see where your strengths and your weaknesses are. So make sure you give it a go. All right. We can all go home, right? Very good. Now, it hasn't. The question was, has that ever happened? And the answer is no. And it is an easy question. I like to start with an easy question, but somebody but no, I'm impressed because somebody always gets it wrong, and nobody got it wrong. Very good. So, what we want to see. Let's get the next 13 correct also. Okay, so why is this question an easy question? Well, once again, remember, it's a case. I took it out of Prosser again. Everybody has Prosser. And you might remember the case from your case book. That helps, remembering the cases. But we look at the call of the question, which is negligence this time, right? If it's negligence, do we care, C, because the band didn't intend to cause the boy's death? No, because that's intentional tort. A, what's missing from A? Nobody picked it. That's good. What's missing? Negligence. Causation, thank you. Years and years and years from now, when you've been practicing law forever, and most of you won't be doing tort law probably, somebody will say to you, what are the elements of negligence? And you'll go, duty, breach, causation, damage. It's something you remember, right? But make sure when you read a question that you make yourself walk through the elements. Elements, elements, elements. In torts and in crim law when we get there too. Elements, elements, elements. So tort is very elemental based, as it certainly was when you took the class. Causation is missing from A. And B, do we need severe emotional distress? Not for negligence, right? Could there have been a cause of action for intentional infliction or negligent infliction? Maybe, I don't know. Not relevant. And remember that about the questions as well. Don't argue with them. Now, if you're doing practice questions, as you're preparing for the bar and you get a question and you want to argue with it, which you will, I promise you, come to me, come to Amar, and we'll argue with you about it. And we may say you're right. But when it gets to the bar exam, you can't do that. You got to take the question as given. We know C is wrong. D is the holding in that case because she couldn't prove causation. Okay, any questions about number 2? If not, number 1, I'm sorry, number 2. Okay, anybody else want to ring in on this one? It's a little bit harder, right? All right, let's see how we did. Ooh, okay, not so good. Now, I know that you haven't reviewed contracts yet, but I can promise you something. You will need to know how 2207 works. I know everybody hates 2207, that's why they like to test it. It's a classic 2207 question, again, taken right out of a case. So what do you do with 2207? First step, 2207 subpart 1, was there a definite and seasonable expression of acceptance? And did we have a definite and seasonable expression of acceptance? Yeah, we did. So an agreement has been formed. Now the question is, does it have an additional term? Yes, it does. Right there, statute of limitations. What do we do with the additional term? We drop down to subpart 2, and now we need to decide whether we have merchants or we don't have merchants. Here's a provision that requires 2 merchants, because subpart 2 says as between merchants. Make sure that you pay attention when you are doing Article 2 questions to whether it's a general rule applies to everybody. Most of Article 2 applies to everybody. Or if you have a special merchant provision, there are 13 of them. And if it's a merchant provision, does it require 2 merchants or just 1 merchant? Firm offer, just a merchant seller. Here we need 2 merchants. Do we have merchants here? How do we define a merchant? Somebody who deals in goods of the kind or holds him or herself out as having special skill or judgment in the trade. They deal in goods of the kind. We have 2 merchants. As between merchants, the additional term, fill in the blank, becomes part of the agreement unless any one of 3 things. First, which they aren't likely to test, the original offer was limited to its terms. It's rarely tested because it's rarely encountered in the cases. Sir?
There's a typo in the answers, like the printed out answers.
Oh.
It says if instead of unless.
Oh, okay, thank you. Yes, thank you. And I will correct that, thank you. And yeah, right. It becomes part of the agreement unless. And and again, the first is if the original offer was limited to its terms, which it's not here. The third, which isn't relevant here, is if the offeror objects when? Reasonable time. Thank you. Not 10 days. Look at what they'll do. They'll give you 10 days. With 2207, it's just a reasonable time. The 10-day rule comes into play in a different merchant provision, which is the merchant's exception to the statute of frauds. Look at the attention to detail. So we're left with the middle, which is unless that term is a material alteration. Now, how do you decide if a term is a material alteration? The comments to 2207, they don't have these cases anymore. I wish they had. There were 3 groups of cases, and it is what you're likely to see tested on the exam. The first is an arbitration clause. We don't have that here. If arbitration is not a custom of the industry. Second is any kind of disclaimer of warranty. We don't have that here. Third, guess what? Change in the statute of limitations. What's the default statute of limitations under Article 2? 4 years. 1 year here. And so what happens to that additional term here? Is it part of the agreement? No, it's not. What are we left with? 4-year statute of limitations. The suit is timely here. So if you struggled with this question, and many of you did, make sure you take a little bit of time to walk through the steps of 2207. If you walk through the steps, you'll get yourself to the right answer. And a lot of people will miss 2207. And the name of the game here is, it's taking you back to your first year of law school, look to your left, look to your right. You just want to get more points than the person sitting next to you. It's the name of the game. And how do you do it on a question like this one? By taking the time to walk through the steps. Any questions about it? All right, number 3. Let's give me another one. And we just checked all of these. Just yesterday, checked them all again. Very good. Okay, anybody else want to bring in on this one? All right. Now, as I watched the results kind of rolling in, the question did exactly what it should have done. And let me get that up. A lot of you got it right. But look what happened with A and B. Now, let me note something. Remember what I told you before. A is a correct statement of law. The market participant exception is not an exception to the Privileges and Immunities Clause of Article 4. It is to the Commerce Clause, but not Article 4. It's a correct statement of law, but it's not the right answer. They're going to give you correct statements of law to distract you. And B is a correct statement of law. That language comes right out of the Virginia lawyer's case, but it's not the right answer. And why not? Reading comprehension. What do we know about Fisher? Fisher's a corporation, and a corporation is not protected by the Privileges and Immunities Clause of Article 4. So, if you picked the wrong answer here, you got distracted, which they want you to do, by true statements of law that aren't the right answer for this question, or you didn't read carefully. And ask yourselves, those of you who didn't pick D, maybe you didn't remember the rule. That's possible. You haven't studied con law for the bar yet. But I'll bet a lot of you just missed that fact. See how important reading comprehension is. Any questions on this one? Okay, number 4. Anybody else on this one? Okay, it's the dreaded property, right? Everybody hates property. And it's a much easier question than you made it. Because I gave you the statute and I told you what to do in the statute. So be aware, if there's a statute in the question, read it and apply it. So take a look. The correct answer here is actually, by the way, D. What? Ah, yeah. Let me get this out of the way. Hang on. Okay. Take a look at the statute. This is a typical tolling statute. And it says you got to bring the cause of action within 7 years. Okay, fine. And then it says the statute of limitations is tolled and the owner gets an extra 10 years. But what do we know about the disability? The disability has to be in existence at the time that the adverse possessor enters. Now, how many of you, think back to your property class, everybody did a problem like this one in your property class. Doesn't matter who you had for property. That's the key. The disability must be in existence at the time the adverse possessor enters. And if it isn't, the disability is completely disregarded. So let's look at our answer choices. Hang on, I got to do it this way. A says the statute of limitations was tolled, but when did adverse possessor enter, before or after the disability? Before. We don't care. And that means B is wrong. And we don't care again with C, when the disability was removed. Possessor entered in year 1. Now notice something about the correct answer here. Some of you may have been cautious about it because it isn't a statement of law. And some people are going to tell you, don't pick a factual statement. That's not necessarily true. Because this fact is what tells you that no is the right answer. So don't be distracted again by statements of law. Don't knee-jerk pick statements of law just because they're statements of law. Make sure they're the right statements of law. And in this case, making a little timeline of the facts. When was the disability found, and when did the adverse possessor enter? And it becomes a much easier question than you might think. And just a word of caution about property, because some of you are cringing every time I say the word. I know. I teach property, right? I know. There are parts of property that nobody likes, or most people don't like. Estates and future interests. Okay, I love it. But most of you don't, right? And most of you, you really didn't get it the first time around. There are very few things that I'm going to tell you, okay, you know, if you don't get it now, then move on. Estates and future interests is actually one of those things. For the MBE, you'll have a couple of estates and future interest questions. And if there's anybody out there who would like to spend some time chatting about it, I love it. But I do. But for your better bar preparation, you don't want to get hung up on the rule against perpetuities at this particular point in time. However, there are areas of property that everybody can get and that they love to test. Landlord-tenant, conveyancing. There's stuff there. Adverse possession, think about it. There's stuff that you can get and that they love to test. So don't just bag property, because there's stuff that's manageable. That's number one. Number two, remember, property questions do tend to be a little bit longer. And people will skip longer questions. Don't do it. Because oftentimes the longer question has an easy call of the question and an easy payout. The examiners know that people skip longer questions. So if you take the time to read through that longer question, oftentimes you're going to find the right answer very easily Other people miss it because they just skipped over it. One final caution, and we'll do the next question. If you do see a question that you want to skip, be very, very careful. I would recommend bubbling something in and then circle the number. The last thing you want to do is what happens to somebody every single exam. Person skips a question and then screws up the grid, and all the choices are off by 1. It happens every time. So don't leave anything blank. Even if you think you don't know the answer, you want to come back maybe later on, put something down. And remember also, they don't punish you for picking a wrong answer. So, you know, if you don't know the answer, close your eyes and point and pick something, A, B, C, or D. Because again, you have a 25% chance of getting the right answer. All right, number 5. Everybody have the new packet? The 14-question packet?
Should, but the new packet doesn't have the answers attached.
Yeah.
So I can go grab them.
No, the answer, no, actually, because I found a typo in one of the, yeah, so we're going to correct that.
Everyone that just asked for them, they don't have that.
Okay.
So
Okay.
everyone should have the new
Okay,
packet.
good. Okay, anybody else on this question? See, you know it or you don't. It's short, it's evidence. And let's see how we did. Okay. Very, very good job on this question. Now, when it comes to evidence, I'm going to suggest some things. Evidence, you know, it's one of those things, you get it or you don't. And a lot of people struggle with evidence, and it can be tricky. And particularly when it comes to character, people freak out about character evidence, right? How many, you know, some of you are thinking that. It's not character evidence here because it's the habit every time, right? And a word of caution on vocabulary words that are used on the bar exam. Probably people have told you already, don't pick absolutes. Because law is not black and white, it's shades of gray, all that stuff you learned in your first year of law school. True, but when it comes to habit, you want an absolute, right? And there are other places. Civil procedure, for example, every pleading must include a prayer for relief, right? There are places where absolutes are the right answer choices. Always be cautious, but don't automatically throw an answer out because it has an absolute word, number 1. Number 2, when it comes to evidence, if you struggle with evidence, it may well be because it's just you got all these rules and they're floating around. What I'm going to suggest to you is an approach that I don't even know who came up with this approach, but I like it. It's a 3-step process that leads you to the rule. Instead of starting with the rules, you kind of back into them. And it can get you to the right result even if you're struggling. So the first thing you want to do, first step, is identify the type of evidence, which is usually fairly easy. Are we talking about a written document? Or are we talking about real evidence, the murder weapon, or testimonial evidence? Identify what it is. When you identify what it is, sometimes if it's real evidence, for example, you might have chain of custody issues. But in any event, focus in and be as specific as possible about what kind of evidence it is. Step number 2, which is the key to getting an evidence question right, is to ask yourself what the evidence is being offered for. Now, most of you are going to jump right to hearsay. Don't. It's your last resort. Why? Those of you out there who have had, if you did trial practice or have competed or anything, you know, if you can't get evidence in one way, you get it in another. That's the name of the game. And that's how it works on the exam too. So do not assume that what you have is hearsay. Think about all the other things that evidence can be offered for: to impeach, to show ownership or control, an element of the cause of action. And be very, very specific. Not just the basic of what it's being offered for, but who's offering it and where. Is it a criminal proceeding? Or is it a civil proceeding? Plaintiff or defendant, direct cross-examination. Narrow it down as much as possible. And the more of that narrowing down you do, the easier it will then become to decide whether the evidence is admissible or inadmissible. So again, don't try to pick out that rule right away. Lead yourself, what kind of evidence, what it's being offered for in great detail, and then finally, admissible, non-admissible. And always, always again, assume it's something other than hearsay. Okay, now, the next question is a Civ Pro question. You all have the new packet, yes? Yes, no. Okay, Amara's going to give, okay, hold your hands up if you don't have it.
So it's not, we're not going number 6?
You are going number 6 on the new set, and I apologize for that. Some of the wrong ones were handed out. Yes. No, the third. Okay. While Amara's passing that out, if we could, thank you very much. Your first step is what kind of evidence. Second step is what it's being offered for. Third then is it admissible or is it excluded? So your third step is where you would apply the rule. Again, what you're trying to do is lead yourself to the right rule instead of sitting there and trying to sift through a bunch of rules to begin with. Okay? All right, and if your packet should have a question that says plaintiff and defendants 1 and 2. That's the question we're going to do now. Okay, let me put the question up. If you don't have it, you can read it on the screen. Okay, anybody else on this question? Hopefully we did well because Professor Nathanson spent some time on this particular issue on Monday. Yes, very good. Now, let's talk about where a few of you went wrong. Most of you got the right answer, and hopefully you remember, we're talking about 1391A, which deals with venue in diversity cases, right? And so the first prong of 1391A says venues proper in any district in which a defendant resides if they all reside in the same state. Do they all reside in the same state? Nope. So that one's out. Subpart 2 says venue is proper where? Where the substantial part of the cause of action arises. In this case, where the accident occurred. And then you've got your fallback, but you don't need the fallback. And remember, Professor Nathanson talked about that specifically. You do not reach the fallback, which says basically any place where a defendant resides, unless 1 or 2 is not available. 2 is available here, which means then that A is the right answer. Now, this is a question that I did develop with Professor Nathanson. I teach a lot of things. CivPro is not one of them. So I always want to make sure when I'm covering CivPro that I have a CivPro professor participate. He said that's a really typical kind of question. And so you can expect to see something very much like that on the exam. Any questions? All right, number 7, which will be it's the next one in the packet. You do. Yep. Okay, anybody else on this one? All right, very good. Now, I don't want you to think that all torts questions are easy, because sometimes you can get lulled into that sense. This question is a relatively easy question if you're paying attention. Once again, I took the case and modified it a little bit out of a case in Prosser. You may remember the case of a person who was driving on a dark road, came over the top of a hill, and hit a black cow, and killed the cow and left the cow in the middle of the road. Thought that was a little bit too gory, so I changed it. But the fact of the matter is, what you want to keep in mind in this question is 2 duties. And that's what makes it maybe a little tricky. We had a few people who didn't get it right. There's a first duty in this case, which is to fasten the suitcases properly, apparently met. But then there's a second duty that unfolds when the suitcases fell. And what the court said in that particular case, and think about it, the guy hits a cow, what are you going to do? The court said you should have done something, put flares out or something to warn other people. And also remember, with the duty, we're talking about the reasonable person. And what is the reasonable person going to do? The example I like to give tied into this, I'm parked out there, and if I walk out when I'm done and I have a bottle of water and I'm packing everything up and putting it in my trunk, put the bottle of water on the top of my car, which we've all done. If I start driving away with the bottle of water on the top of the car and somebody in the parking lot is going like this, should I stop? Probably I should. A reasonable person would, because the bottle might fall, it might hurt somebody, it might dent a car or something. But if I manage to get all the way out onto the Palmetto and I'm driving along at a pretty good clip on the Palmetto going home and somebody driving next to me is going like this, am I going to stop? I'm not. I don't know about you, but I'm not stopping on the Palmetto. So it's the reasonable person in the circumstances of the defendant. Okay, any questions on number 7? All right, number 8 then. That's the question you're doing now. That's the second half. Do you want me the first half? Oh, okay. Mm-hmm. You got it, yeah. Okay, anybody else on this one? There's your right answer. Now, a couple things I want to point out, and something I should have mentioned when we did the first question, but I want to make sure I mention now. Whether it is an MBE contracts question or an essay contracts question, what is the very First question you must resolve. What's my governing law? Don't forget. And governing law here is obviously Article 2. It's shopping bags. They're movable. When you are writing an essay, as we'll see next week, because we're going to do contracts next week, the very first thing you have to do always, always, always is identify the governing law. So Article 2 governs, and 2306 in particular. Do you need to know section numbers? No. And you'll see when I talk about subjects, and I can't tell you why. I learned Article 2 by the numbers. And so if I say 2306, then I know right away what it's about. When I talk about evidence, I don't talk about rule numbers because I didn't learn it by rule numbers. Who knows why? You don't need to know numbers anywhere except in con law. You need to know that it's Article 4, privileges and immunities or whatever. But everywhere else, numbers don't matter. Requirements contract, though, vocabulary does matter. Why did I put this particular question in? Because I wanted to illustrate what I talked about before. They're not going to test the basic rule. Outputs requirements, pretty simple to see. When you have an increased demand, you know what to do with it. This is the other side of the coin. What do you do when there is no demand? It's not a rule that you probably talked about in your contracts class. How many of you took sales? A few. Did you talk about it in your sales class?
Yes.
Yes.
Well, I know it's a good class.
Yeah. Well, and it's something that, and the point here is, if you had a good contracts class, and I'm sure you all had a good contracts class, you did not cover everything that's testable in Article 2. A lot of stuff. You may not have spent much time on warranties. You probably didn't spend time on no demand and other things having to do with the performance phase that you didn't cover. So don't assume you know everything there is to know about Article 2. The increased demand language, unreasonable demand language in 2306 subpart 1 applies to increased demand. If there is no demand, the question then becomes why, which is what D is telling us. And there's some inconsistency here, but the case law is very clear. I took this out of a classic case in that area. If the reason for no demand at all is that the buyer is closing up shop, going out of business, then it's done in good faith and there's no breach. If the reason is just to save money, no good. Now, why are you going out of business? To save money. But there is, that's why I say, to me, it's always been a little, but there's the case law, very clear. If you're going out of business, and this was based it on a case dealing with breadcrumbs, then there's no breach. If you're just trying to save money, it's a breach. All right, number 9.
The office was locked.
Okay, thanks. Yeah. Okay, let's see what we have on this one. Pretty good, not perfect. Couple of things to note. D is the right answer. First of all, they like to test threshold questions when it comes to con law. So be aware, mootness, ripeness, standing, all those threshold questions, very important. And something I want to add, we'll talk about again when we get to Florida con law. They love to throw little threshold questions into essays on the Florida portion of the exam. So always be on the lookout for them, particularly if you get a con law question, but sometimes other kinds of questions. So standing, mootness, ripeness shows up more than you might think on the essay portion of the exam. Now, can anybody tell me there's a phrase in the fact pattern that just is a dead giveaway on this question? Class action, thank you. It's a class action. If there's a class action, even though the named plaintiff no longer fits the criterion, you still have a live controversy. And in this particular case, this problem is also what phrase? Capable of repetition yet evading review. Ah, yes, so you have two here, but really the key is in the class action. Make sure when you are reading questions, make sure you stop and say, what's this phrase doing here? You see class action, it should have made you think about something. Okay, number 10. Anybody else on this one? Okay, pretty good. C is the right answer. Now, as I mentioned a little bit earlier, when it comes to the crim pro, the bar considers crim law and crim pro to be one subject, but they clearly are not. They're very different. Crim law is the substantive criminal law. Crim pro is 4th, 5th, and 6th Amendments mostly. It's a crim pro question. It's all about the cases, right? Because think about it for a second. When it comes to con law and crim pro, if it's constitutional, you're looking at Supreme Court decisions. And you guys had 3 years, some of you 2.5 years of law school, enough to know that the Supreme Court's going to do what the Supreme Court's going to do, right? So knowing the holdings in the case, it's key. And we know that the Supreme Court has held, if you're just a social guest, you do not have standing to object to a search. It's that simple. So as you go through your materials, just a word of advice when it comes to con law and crim pro. Look at the case capsules in the materials and refamiliarize yourself with those cases. The more you recognize the cases when it comes to those two subjects in particular, the better you're going to do on the exam. In your con law classes, your professors may have made up questions that asked you to stretch the bounds. What do you think the Supreme Court might do in such and such a case? They don't do that on the bar exam. They can't do it on the bar exam. If they're testing con law or criminal procedure, it must be based on a real case. And the answer, the correct answer, is the holding in that real case. So just remember that as you do those questions. All right, number 11. You're going to love this one. It's property, you bet. Extra pages. Okay, anybody else on this question? Thank you very much. All right. Anybody else to ring in? All right. D is the right answer. Now, I am impressed because it's just a tough question, and you guys did well on this one. Reading comprehension. And those of you who were in ALS, you've heard this shtick before. That me for property, you've heard it before too, but it really works. The first thing you have to do is look at your statute and decide whether it's a notice or a race notice statute. It's highly unlikely they're going to give you a race statute because it's too easy. So it's almost certainly going to be notice or race notice. What you have to figure out from the statute is who has to record. If just the first person has to record, it's a notice statute. If the first person has to record to protect against the second person who also has to record, two people have to record, it's a race notice statute. And how do you find that? From the language of the statute. Look at who's required to record. How many times does the statute tell you somebody has to record? Once, it's usually a notice statute. Twice, race notice, not surprisingly. Well, first, duly recorded and duly recorded. It tells you that two people have to record. It's a race notice statute. Now, if it's a race notice statute, then you need 4 things. You need just 3, the first 3 if it's notice, 4 things if it's a race notice statute. You look for the person who is subsequent. You're going to have 2 claimants at the bottom of 2 chains of title. Who took last chronologically? That's your subsequent person. So you got to draw some kind of chart, however it is that it works for you, so you can distinguish between your chains of title. So that's number 1. Who is subsequent? Second question, is that person a bona fide purchaser for value? Now, the good news is when it comes to the bar exam, they're not going to split hairs on value. There are some very complicated cases, which you probably did in your property class, because they're in the Duke Maneer casebook, that deal with when value is given. For the bar exam purposes, it's all or nothing. They paid value, or it was a gift. If the subsequent person took by a gift, of course, that person's not protected. But assuming, as is the case here, that value was given, third step, did that person have notice? Was the prior deed recorded in the right place? And then fourth here, did that person record first, the subsequent person? Go through those steps, 3 steps for notice, subsequent, bona fide purchaser for value without notice. 4 steps for race notice, subsequent, bona fide purchaser for value without notice, who records first. And if you go through those steps and you read the statute correctly, you will, as many of you did very nicely with this question, you'll get the right answer. Now, why does that matter? You will have recording questions on the MBE portion, number 1, and many people will get them wrong. Once again, you want to get the questions right that somebody else is missing. And number 2, they include recording on the Florida portion of the exam with a fair amount of frequency. Florida has a notice recording statute, so jot that down. And you'd be surprised at how often it comes up in the context of a Florida essay question. So mastering recording is really, really important. Okay, we're getting to the end. I know everybody's getting tired. Number 12.
didn't even, I was not, I, well, maybe, I don't know if it's right, but I just like, yeah, it's like, if you're gonna do that, you're gonna do that, and then you set up what you want to do, see that, and then I didn't know that either, but then still, that's right, then.
Okay, anybody else on this question? And I'm hearing a lot of debate, and it's good debate, but anybody want to tell me what the most important word is? Least likely. So you're all sitting there debating, but that one looks good, that one looks good, that one looks good. Yeah. 3 of them are right, 1 is wrong. Least likely. So what's going on in this question? It's actually a pretty simple question. Counterclaims. That's not really rocket science. It's a reading comprehension. And the one that's clearly wrong is B, because it says seller must bring a counterclaim against buyer if seller's claim arose out of the same contract that gave rise to buyer's I'm sorry, I read the wrong one. Sorry. May elect to sue buyer later for breach of contract, but only if seller's claim arose out of the same contract. That's not right. The rest of them are all right. If it's a compulsory counterclaim, it rises out of the same transaction. Yeah, it has to be brought. That's A. And C is a permissive counterclaim because it arises out of a different contract. And D is also a permissive counterclaim. So, word to the wise. As many of you were doing, and the debate was a good one. I always like to listen when I give this question. If you see, first of all, 3, and you're going, but wow, they all look good. That should tell you something. Make you go back and look at the call of the question, right? And reading comprehension is so important when it comes to this exam. And here we are, we've been at this for, an hour and a half to hour and 45 minutes. You're getting tired, you're losing your focus. That's exactly when you make stupid mistakes. So keep your eye on the ball. When you're tired, then double the effort. Okay, we have just 2 more to go, so number 13 and then 1 more after that. Anybody else on this one? Maybe we're getting tired. Maybe we haven't reviewed evidence yet. All right. There are several things going on in this question, which is, again, why I want to do a question like this one. There are, first of all, a couple of layers. You got to take that statement, what is it, right? The statement by the husband, yeah, I knew they were hot, that's a what? It's an admission. But a step beyond it, is it protected by a privilege? So oftentimes on the MBE, you have to use more than one rule. Really important to remember that. Don't stop with the first rule that comes to mind. You may need that rule, but then you may need to apply a second rule after that. And oftentimes that happens in evidence. So we identify the statement as an admission. Now we ask, is it privileged? There are two privileges that we need to consider under the federal rules in respect to married persons. We have marital communications and we have spousal immunity. And you've got to keep them separate and understand the rules. They love to test this stuff. So let's start with spousal immunity. The parties have to be married when? When the testimony is elicited, right? And who owns the spousal immunity privilege under the federal rules? The witness spouse does. Who is it who's trying to block the statement here? The defendant's spouse, right? So spousal immunity is present in this case, but who has waived it? The witness, the wife. So husband can't do anything about her testimony under spousal immunity. But marital communications, the parties have to be married when?
During the communication.
When the communication is made, and of course the communication has to be made in the confidence of the marriage, which it was here. They're sitting around on the breakfast table and it's just the two of them. Who owns the marital communications privilege? Both do under the federal rules. And so while the wife can waive it, doesn't mean the husband is waiving it, he can still raise it, which is why A is the correct answer here. So you got a lot of layers going on in this question. It's a pretty straightforward question, but if you rush through it, you're going to miss the layers. All right, now, before we do the last question, when we finish the last question, I will draw our winner. So don't rush out of the room as soon as we're done with question 14 so that you can find out if you won. But in the meantime, number 14. I'm going to see if anybody else needs to. Kelly, thanks. And I am walking around in case anybody else did not. Oops, sorry. All right, anybody else on this one? All right, going once, going twice. And let's see how we did. Now, can anybody tell me what's the most important word in this one? Attempt. It's at the end, you're tired, you're not paying attention, and maybe you really didn't pay a whole lot of attention to common law in your criminal law class. Attempt, any kind of attempt at common law, is a specific intent crime. A number of you picked C, and if somebody had died, yeah, you got reckless disregard for human life, no question about it, but nobody died. It's attempt, specific intent. And do remember this. I see some faces out there that I had in criminal law. I spend more time on the common law than most of your professors do because the bar exam tests the common law mostly. So if you spend most of your time talking about the MPC, which many professors do, you kind of have to set it aside and really learn the common law of criminal law. All right, now, I'm going to mix this up, and as I'm mixing it up before I draw, next week, as I mentioned before, it's introduction to essay writing. I will give you my predictions such as they are for what I think they're going to test. And if there are some of you out there at Lorena, for example, who you're not taking the Florida exam, this particular session, it's contracts and torts, and I'm doing products liability in torts this time. So even if you are not taking the Florida exam, it can still be very helpful to you, and it will help you with both parts of the exam. So let me pull somebody out now. It's mixed up as I can make it. Where's Eric Rodriguez? I saw you out there before. There's Eric. Yeah. All right. Okay. Our winner for today. Come back next week, and you got another chance. Have a good weekend.